Hi, my name is William DeNardo, and I am a defense attorney here in Montgomery County, Pennsylvania. Prior to being a defense attorney, I was a prosecutor in Montgomery County. As both a prosecutor and a defense attorney, a lot of the cases or the subject matter that I've handled has involved DUI, or driving under the influence cases. A question that I'm often asked by people is, as a defense attorney, what can you really do with someone who's been accused of driving under the influence of alcohol or a controlled substance? Isn't the reading, the blood alcohol concentration reading, sort of the beginning and the end? The bad driving, the careless driving that was observed, doesn't that sort of tie your hands, Bill, as a defense attorney? And what I tell them and what I would tell you is, what you need to understand is that driving under the influence prosecutions are incredibly complex. Surprisingly, maybe, because they seem sort of garden variety. You hear about them all the time. But there's a lot of factors that go into a prosecution for a driving under the influence case. There's the stop itself. Did the officer have a reasonable suspicion to pull a vehicle over? That's not always a clear-cut thing. There's scientific evidence. There's chemical testing. There's blood alcohol concentration determinations that are made sometimes by not even testing the blood itself, but instead extrapolating the blood alcohol concentration from a breath test. The testing apparatus has to be checked. It has to be calibrated. It has to be tested for accuracy. It has to be done in a prescribed way that's regulated. The testing facility, the hospital, has to be approved. There has to be notice of the facility that's meted out to the public. And when you start digging into these cases, you sometimes find that shortcuts have been taken or things are out of order. And that's what you as a defense attorney need to look for. There's a whole physical aspect of a DUI. There's field sobriety testing. There's roadside physical type of tests that are oftentimes requested by an officer arresting someone for suspicion of DUI. Those are sometimes open to interpretation. More and more you see police vehicles that are equipped with cameras that record video. I'm going to use the old school term video record the stop and the field sobriety tests. And oftentimes when you watch those, what you see doesn't always match up with what has been reported by the police in their written reports. Those are the types of things that we look for, and that I look for, obviously, as a defense attorney. My job, and part of my job, is to advise clients who are accused of DUI with how strong the case is against them. And to do that, you need to have some experience, obviously. You need to have tried cases before, which I clearly have. And you need to have a pretty firm grasp on what to look for and where to find it, which is in discovery. I try to put my clients into a position where they know exactly the strength of the weakness of the case against them and advise them accordingly. If I have a client that makes the decision as someone that's presumed to be innocent and criminally accused that they want to take their case to trial, if it makes sense, I have no problem taking cases to trial. I've never said no to a fight. So if you need somebody, if you're in the position where you need some help, you need counsel, someone to tell you what you're looking at, how strong that case against you is, your chances of success, and someone that's not afraid to take something in, I'm the guy you need to be talking to. Bill DeNardo, criminal defense attorney.